At Pepperdine, you'll not only see policy differently, you'll see your future differently from here too.
Good afternoon. Hello. And welcome to Pepperdine School of Public Policy. I am Pete Peterson, Dean here of the Graduate Policy School, and very happy to be hosting a conversation on such an important set of issues. The title for today's discussion is The Unexpected Consequences of Climate Change on Government Finance. And we have several experts on the subject to talk us through. This panel will be led by Dr. Micheal Shires, our Associate Dean for Strategy and Special Projects, but also an expert on local government finance. And he will introduce our panelists and the format for today's discussion. We are a unique graduate policy program. For those of you, this may be your first time here. We're in our 20th anniversary as a graduate policy school that was founded by folks like Jack Kemp and James Q. Wilson and Michael Novak and others who understood that preparing public leaders as opposed to preparing bureaucrats demanded a different kind of education. And so if you look at our core curriculum, it uniquely balances the quantitative parts of policy analysis, but it also looks at history and political philosophy. And when you look at even subjects that tend to be so quantitative and complex, like climate change and local municipal finance, there are still issues undergirding them that have both history and political philosophy. Specifically, what is the role of government in some of these issues? And what are the role of free markets? What is the burden that should be placed locally, and what is the burden that then should be considered for outside agents or the private sector itself? At the same time, we are a graduate program that prepares not just people to work in government, but also to work in the private sector as well as the nonprofit sector, from think tanks to policy-related organizations. And I hosted my once a semester Dean's discussion just yesterday with our students, and one of our students had offered that they would like to see some more discussions led by people working in the private sector, but policy-related private sector. And so this is certainly one of those issues that cuts across sectors, from the private sector and nonprofit sector actors, and certainly the public sector as well, but also with different levels of government, from the municipality all the way up to the federal government. We'll be discussing those lenses through which we can look at this set of very difficult issues today. So again, I want to welcome you here to Pepperdine. I hope you have some time after this event to walk around and see the views here. Specifically, I point you to our Heroes Garden just off the side here to the left, which commemorates 9/11 and one of Pepperdine University alums who was killed on Flight 93. As someone who grew up in New York, it's really it's been an interesting full circle in my own life to see a school here on the other coast commemorate and memorialize really in some important ways such a great tragedy in American history. So without further ado, thank you all for coming, and let me welcome up Dr. Micheal Shires to facilitate today's conversation.
Good afternoon. It really is a pleasure to be here with all of you. We have a great group of panelists. I'm not going to take too much time. Let me just make some room here. I'm not going to take too much time talking about, but I do want to provide a little context for the conversation that we're going to have today. The idea of cities suing the oil companies for economic damages, cities suing oil companies for damages along a range of issues is not new. I mean, whether you look at asbestos or tobacco, I mean, there's been a history around some of these issues. This particular conversation mostly dates back to about 2008, when the little village in Alaska was facing rising sea levels and sued Exxon, claiming that in fact it was the impacts of the oil industry and climate change on the environment through the climate change mechanism that was resulting in the need for that village to relocate. The peninsula they were on was being flooded, and they didn't have any money to move. And so they tried to reach into the pockets of the oil companies to fund their relocation. That lawsuit went the full 9 yards and was eventually dismissed in 2012. That was in 2008. In November of 2015, the New York Attorney General announced an initiative to investigate Exxon Corporation's knowledge that since the 70s they'd had experts telling them that climate change was causing lots of environmental damage, and that they had suppressed that research and that information, and in fact advertised on the opposite side. Soon after that, a year after that, so that was November 2015, a year later, May 2016, the US Virgin Islands announced a similar initiative, and right after that, the state of Massachusetts, the Attorney General there, all announced these investigations into Exxon. Exxon, of course, did not take this lying down. They filed a counterclaim in Texas, saying that this violated their rights and there really wasn't any basis for these lawsuits. That led immediately to the Virgin Islands withdrawing their claim and their subpoenas. New York and Massachusetts to this day are still continuing those initiatives. And in the course of that process, the lawsuit got moved from Texas to New York. So a much friendlier environment for the New York Attorney General. More recently, though, and what brings us to our conversation today with that backdrop, is that in July 2017, 2 counties in California, Marin and San Mateo County, and the city of Imperial Beach filed lawsuits against 5 major oil companies and I think about 17 or 20 affiliates, claiming damages associated with climate change. And these lawsuits, they were followed in September, 2 months later, this is last year, 2 months later by the city of San Francisco and the city of Oakland. And then in December of this year, the city of Santa Cruz and the county of Santa Cruz also both filed. And all making claims that rising sea levels in the Bay Area were going to have serious economic impacts on their communities and demanding damages from these oil companies. In January, in fact on January 8th of this year, Exxon filed a countersuit observing one very interesting thing, and I just want to read a couple quotes from the Oakland case. Exxon observed that while they were filing these suits for damages from climate change, they were also issuing bond statements that said they saw no foreseeable future risks from the impacts of climate change. So they were literally filing legal documents in both settings. In Oakland's case, for example, they spelled out in their lawsuit that by the year 2100, the city's likely to have up to 66 inches of sea level rise, and that along with the flooding, it will threaten their sewer system and property at a cost up to $38 billion. And yet last year in a bond filing, they told investors that, quote, the city is unable to predict when events such as sea rise or other impacts of climate change could occur, or when they may occur, or their impact on the local economy. And so there's a little bit of a disconnect between the two pieces. In Exxon's filing in January, they pointed this out. That ironically, that had the impact immediately of New York City announcing 2 days later that they were filing a lawsuit on the same basis of climate change, January 10th. 3 days after that, the city of LA introduced a motion in the city council, which hasn't gone to full fruition yet, investigating whether the city of Los Angeles will file such a suit. And on January 23rd, another Bay Area city, the city of Richmond, filed a lawsuit against the oil companies as well. And so there's this kind of rich history. California is definitely the front runner in this, although some of the conversation obviously originated elsewhere. And today we're here to talk about not so much the debate over climate change, although it's certainly a backdrop for the entire conversation, but really to address the question of what does it mean when cities make conflicting claims in these filings? And what are the implications of that to the public policy process and to the economic systems that they're operating in, whether it's the legal system and nuisance claims on one side, or whether it's the bond markets on the other side. So to address that question today, we have 3 fantastic speakers, and each of them is going to have an opportunity in our format here to give sort of 5 minutes or so of opening remarks. And then we will turn it over to kind of a moderated discussion with time at the end for questions from the audience. And so our first panelists, I'll just go through and introduce all 3 of them, and then we can just present this order. Our first panelist is Anthony Casso, who earned his JD from the University of the Pacific with George School of Law. and an MBA from the Golden Gate University. Professor Casso joined the Chapman faculty in 2008 as a visiting associate clinical professor and director of the Constitutional Jurisprudence Center. Prior to joining the faculty, Professor Casso held a variety of positions at the Pacific Legal Foundation, including service as its senior vice president and chief counsel. Professor Casso's litigation experience includes all levels of government, and he successfully litigated cases in state and federal court, including the state Supreme Court and the United States Supreme Court. He's taught as an adjunct professor of state constitutional law at McGeorge School of Law and an adjunct professor at the University of San Francisco College of Professional Studies. In addition to directing the Constitutional Jurisprudence Clinic, Professor Casso teaches administrative law. Our second panelist is Mark Jaffe, a senior policy analyst at the Reason Foundation, where he researches public employee pensions and other government finance issues. Mark's research has been published by the California State Treasurer's Office, the Mercatus Center at George Mason, and the Haas Institute at UC Berkeley. His op-eds have appeared in the Fiscal Times, the Orange County Register, the San Jose Mercury News, and the Guardian. Before entering the public policy sphere, Mark held a variety of roles in the financial industry, including 9 years as a product manager and technology manager at Moody's Analytics. Mark received his MBA from NYU and his MPA from San Francisco State. His latest study on credit agency regulation was released today, I guess, at reason.org. Our third panelist is Francis Minton. Francis retired from Wilkie Farr and Gallagher Limited Partnership on December 31st, 2015, after more than 40 years, 31 of which were as a partner. At Wilkie Farr, he practiced in the area of commercial litigation and conducted more than 30 trials in state and federal courts around the country. He served for many years as the co-head of the Business Litigation Group and also for 15 years as the chair of Conflicts and Ethics Committee. Currently, he has a solo practice specializing in commercial litigation and issues of conflicts and legal ethics. And probably most interesting, and I think he probably has the most fun with it, he is the Manhattan Contrarian. He has a blog site where he rejects and in fact pushes back the intellectual orthodoxy that has come to dominate our public dialogues. Just a footnote in his political background, he served as an economic advisor to Barry Goldwater during his runs for president, and he's also been a visiting professor at Columbia, among other places.
I think I was 12.
You know what they say on the internet, it never goes away. So with that, I'd like to invite Anthony Casso to give his remarks. You're welcome to stay in your chairs or come up here as you feel more comfortable. And I will try and keep you guys to 5 minutes.
Well, good afternoon, and thank you for the invitation to come out to this wonderful place, although it is quite a drive to get here. The WAYS program is awesome. You get to go see neighborhoods you never knew existed. But what I want to talk to you about is sort of what was hinted at here, is that the gap between the claims. My experience is in litigation, not in bonds. I teach at the Fowler School of Law at Chapman University. I teach the students how to craft litigation, how to write briefs, get their legal arguments together and present them to the courts. So when there's a gap between what you're saying in your litigation and what you're saying in other public documents, we have this disconnect here that we need to figure out. So what's the gap? The Oakland situation was talked about, but I picked apart the San Francisco complaint, since they're right across the bay. And if you know anything about San Francisco and they talk about Oakland, they say there is no there. So it's all about San Francisco. They're claiming to sue on behalf of the state of California. And they are saying, this is one of the allegations, global warming is here and it is harming San Francisco now. It's already causing flooding, erosion, and impacts on the water treatment system. There is an imminent threat of catastrophic storm surges and flooding. They talk about a plan that they adopted in 2016 to assess the dangers of global warming. So they knew it was coming. It's been on their minds for a while. They look at what's at risk in terms of public property. More than $10 billion of public property is at risk from global warming, and more than $39 billion of private property. This is all in their complaint that was filed in San Francisco. They state by the year 2050, San Francisco is expected to have a 100-year flood twice a week. So they'd have to rename the 100-year flood, I think. And a 500-year flood every 4 years. Another 50 years down the road, they're going to have a 500-year flood every week. So I guess that becomes the weekly flood, and the 100-year flood becomes the daily flood. I don't know, but that's the allegation in their complaint. So dire things are happening. That's their complaint. The disconnect comes is when you look at the disclosures in their bond prospectus, and you're gonna talk about that in more detail and what the legal ramifications of that are. But in their bond prospectus, they do actually cite a report that talks about this private entity has come up with potential damages from global warming. And they listed that. It's a fairly lengthy paragraph. But then the next immediate paragraph says, the city is unable to predict whether sea level rise or other impacts of climate change or flooding from major storm will occur, when they may occur, and if any such events do occur, whether they will have a material adverse effect on the business operations or financial conditions of the city and local economy. Sort of a big difference between $39 billion of private structures are going to be wiped away to, oh, we don't know. So why is there disconnect between the two documents? Well, in bonds, and I'll let the other panels talk about whether or not it affects the bond prices. If they're out there and they have big bold type saying the city's going under, but loan us money. And there's also legal requirements of disclosure, what they have to disclose, and the factual basis for that. That's also going to be talked about by the other panels. In litigation, there's also some legal requirements of disclosure. In the first place, you can't have a lawsuit unless you have a real injury. So they can't have the statement they have in their bond prospectus in their litigation complaint. They can't say, we're not sure, we have no opinion on it, because they want someone to pay them money. And in order to do that, they have to identify a real, honest-to-goodness injury that they are really, really, really going to suffer. It can't be a guess. It can't be speculation. Because you just can't go to the industry and say, give us billions of dollars because something bad might happen someday. The court's never going to approve that type of a case. So they have to come up with real damages. And that's where this disconnect between the two public documents come up. What's kind of interesting is that they actually cite it in the litigation that they want the court to brand these cases the same as the big tobacco litigation. And they even cite to the big tobacco litigation. And this is just like big tobacco that hid the dangers of smoking, because Exxon and Chevron and all the oil companies hid the dangers of global warming. So what do they want out of it? Presumably they say they want damages so they can build big seawalls so that the 400 or 500-year flood won't be so bad for them. At the end of the day, they want cash because they've got some private attorneys involved in this for a contingency fee of roughly a quarter of whatever they're able to get. The interesting thing is they're only suing, if you take global warming on its face, they're only suing about 7% of the problem. The other 93% of the causes aren't in this case. So how that's going to play out for the court's going to be very interesting. Can you be the public nuisance if you're only 7% at fault? Are they going to have to bring in the other? They have to bring in China and Russia and the other companies. They have to bring in the coal companies, who don't have any contact with California, so it'd be hard to bring them in. But this is going to be the challenge for them in the litigation. One of the things that they may be doing, I'm not going to accuse them of this, but some people in litigation will try and make the case as painful as possible in order to get it done. Is that what they're going for? Are they just looking for cash? there's probably too many cases already for that to be a good strategy. So where is this gonna go? It's gonna be a very expensive case if the courts allow it to go to trial. And they're gonna have to prove that somehow Exxon and Chevron and ConocoPhillips and these other companies are the major contributors to what they think is going to happen. They're gonna have to prove that these things will happen. They'll have to prove that these defendants are the cause of it. They're gonna have a tough time tying those two together, however. But in the meantime, they might have some problems with the other public documents where they've come out and said to the investors, we're not sure. We don't know what's going to happen. So with that, I'll turn it over to the expert on the SEC disclosures.
Before I got started, I just wanted to key into something that Mike said in the opening. I'm of a certain age where I was a kid in the 70s, and I was a kid who was really, really obsessed with weather. And back in the 70s, we had a lot of cold winters. We had record snow in 1969 in New York City, and we had a lot of days where it got below 0 degrees. And I very well remember a lot of newspaper articles, magazine articles, and people on TV talking about the new ice age. And as I recall, there was a lot of pollution back then. There was a lot more pollution coming out of the tailpipes of cars in the 70s than there is today. So I'm not quite sure how we got from the new ice age to global warming, but it sort of makes me wonder. So now back to my prepared remarks. Lying or misleading on a securities disclosure document, an offering document, is a thing, and it is a thing that the Securities and Exchange Commission doesn't like and that they often take action against. The relevant law dates all the way back to the Great Depression, citing Section 17A of the Securities Act with some ellipsis there, but this is the key point. It shall be unlawful for any person in the offer or sale of any securities to obtain money or property by means of any untrue statement of a material fact or any omission to state a material fact. So it seems pretty consistent with what we just heard, that there's a problem here because if what San Francisco, Oakland, Richmond, and the other cities are saying in their lawsuit is true, it seems that they've both omitted facts and even made untrue statements. So there's actually quite a number of SEC actions against municipalities for false or misleading disclosure. Just want to take you through a few of these examples. If you're interested, I can provide you with the slides later, and there are links to the original SEC documents that show where the complaint was, quotes from the relevant SEC officials, and so forth. The first two involved pension disclosure. That's the thing I work on at Reason, public pensions. A lot of states and cities have incurred very large unfunded liabilities by not paying their actuarially required contributions each year into their pension funds. So as a result, those pension funds are deeply underwater. And the SEC came to the conclusion that states issuing bonds really needed to come clean with investors about that situation. And in the case of New Jersey in 2010, they concluded that the state failed to do that and entered into a settlement agreement with the state. And similarly in 2013, once again, the state failed to disclose that statutory plan significantly underfunded the state's pension obligations and increased the risk to its overall financial condition. And as many of you who follow public finance know, Illinois is really at the bottom of the barrel in terms of credit ratings and fiscal stability, and a big part of that is the $110 billion plus of unfunded liabilities that the state has for its various pension schemes. But it hasn't only been pensions. So in 2016, the SEC took action against 71 different municipal filers. In this case, the issue was that in a bond filing, the agency said that they had issued all of their continuing disclosure statements as required in previous bond covenants. So to just unpack that a little, most municipal bond issuers, most cities, states, counties, issue an annual report, just like a company issues an annual report. It's called a CAFR, a Comprehensive Annual Financial Report. Cities and the other issuers are supposed to upload those to the Municipal Securities Rulemaking Board's website, which is called EMA. But it turned out when the SEC started investigating this in 2014, that a very large number of municipal issuers were failing to do that. And so as a result, they started contacting issuers and also saying we're going to have a voluntary compliance period where you can sort of get right with the law, and then after that, we're going to start taking action if you don't get right with the law. So this ultimately was the consequence, 71 actions. Then there have been a lot of smaller cases that I just wanted to quickly highlight. In two of these four, there are agencies that ultimately had a bond default. And so I tend to think that the SEC gets really interested when it's a low-rated credit or it's a credit that actually has a default. So in the case of Victorville in the high desert, they had an airport that borrowed money based on inaccurate property valuation. They were using, I think, sales tax revenue bonds, and they didn't generate enough money. The city's fiscal condition has been compromised, and the airport authority defaulted on its bonds, and eventually it attracted the SEC's attention. Harrisburg, for people who remember back to 2010, just been a complete basket case as far as municipal credit quality is concerned. They had a solid waste disposal plan, which went way over budget. The city's finances were shaky already, and that tipped them over into municipal default. And they actually filed for a Chapter 9 bankruptcy, but it was dismissed because the state of Pennsylvania doesn't allow Chapter 9 bankruptcies without state approval. Oddly, though, I did find a couple of cases where you had a solid filer, a solid issuer that also faced SEC action, and those were the cases of the Westlands Water District, where they did some creative accounting to get their debt service coverage ratio to match what they had stated in their offering documents. And then the Port Authority of New York and New Jersey, which apparently borrowed money to build a project that they didn't have the authority to build. So interesting challenge there. So I just wanted to say, the SEC has a whistleblower program, and if you believe that global warming is a thing, and you think that cities are misleading municipal bond investors by not fully coming clean about their exposure to global warming, here's where you can file your complaint. And if the SEC settles with one of these agencies for more than $1 million, you get a whistleblower commission. So hopefully everyone will run to the internet. And thanks very much for your time. If you want to contact me, I'm with the Reason Foundation, and as you heard earlier, we just issued a report on the credit rating agency business. Love to hear your feedback about it. Thanks.
So I'm Francis Menton, the Manhattan Contrarian, and maybe relevant to this current event today, one of the things I'm doing in my small legal practice is engaging in, I guess, the other side of this climate litigation, which includes filing comments with the EPA, which includes Freedom of Information Act requests against our illustrious Attorney General Eric Schneiderman, and other things that are relevant to this. In fact, our Freedom of Information Act request to Eric Schneiderman, one of which I argued in the appellate division in New York. We lost it. So I was in the appellate division in New York just last week, but it relates to the documents that underlie his investigation of Exxon, which is at issue here. Dean Shires took you through some of the things that, the sequence of the investigations and the counter lawsuits of Exxon. And I have a few things I want to add to that to begin with, and then after that, I'm going to address the questions of how some of these litigation scenarios might play out, and ultimately, if I get time, where is Exxon going with this? Why are they doing this strategy versus something else? First, a few things to add. The Schneiderman investigation, Schneiderman began what he called, with a press conference, a criminal investigation against Exxon for misleading its investors in its securities disclosures. That began in 2015. Any criminal charges? We're now in 2018. Answer, no. Nobody's heard of anything of where it's going now. They did subpoena Exxon and they collected, nobody knows how many, but probably in the millions, maybe tens of millions of documents, but no criminal charges. The Exxon lawsuit brought in 2016, what were they seeking? They were seeking mainly the depositions of Schneiderman. They wanted Eric Schneiderman, Attorney General of New York, to show up in Texas for a deposition. And the Attorney General of the Virgin Islands, who had commenced his own proceeding, they were seeking the depositions in Texas. There was a hearing held. The judge was quite critical of Schneiderman at that hearing, and people thought he might do something, but when the time came in March 2017, what he actually did was transfer the case to New York without granting any relief. And so the case has come to New York and gone nowhere. That case was in federal court. The new Exxon case, which was commenced in January of 2018, that one is in state court in Texas, also Fort Worth, Texas. And that's an interesting question. See, if you were in the litigation business for 40 years like me, you think about, look, Exxon's from Texas, they're not from Fort Worth, Texas. So what's going on here? The federal court case was also brought in Fort Worth. I don't know everything that's going into Exxon's very clever forum shopping, but I would suggest that the fact that Fort Worth, the 5th largest city in Texas, is actually the most Republican city in Texas, might have something to do with that. Judges are elected in Texas, state court judges. So those are just a few points to add into the mix. Effect on the bond market. Does anybody think that if only San Francisco disclosed these projections of sea level rise, that they would not be able to sell bonds, or Oakland, or San Mateo County, or Marin County, or that their interest rates might go up? First of all, I think there's no subject in the world of which there's more information in the public than this one. And the second thing is, it's complete BS. Now, in my comments to the EPA that I've actually filed one on Monday, one of the issues that we addressed was sea level rise. Is there anything to the prediction of sea level rise? The answer is no. Sea level has been rising about 6 inches a century since the last ice age. No reason to think it's going to rise at anything other than 6 inches a century for the rest of our lives and our children and our children's children, and on until the next ice age, when it will go back down. There's a lot of reasons for that. I'm not going to try to get into the science here in a short amount of time. Do the municipalities here face any serious risk from the potential private securities lawsuits, or how about from the SEC? Well, first of all, private securities lawsuits. I don't know how many people follow that business. Obviously, I did for a long time. There's almost no such thing as a private securities lawsuit involving bonds. Why is that? Because until it's in default, hey, we're paying. You're only entitled to be paid. It's not like a stock that could have gone to 1,000 if you hadn't defrauded me. The bond, you're only entitled to be paid back. As long as we're paying, what's the harm? And other bad news for people wanting to bring these lawsuits, in a bankruptcy or a default situation, a securities lawsuit is subordinated into the class of debt to which it belongs. So therefore, a bondholder never will get anything more than his claim on the bond, even in a bankruptcy. Now, the SEC is a different story, but will the SEC actually impose fines? And I'll defer to Mark on that, but if it's not fines, then it's a supplemental disclosure. Oh, we're going to make the municipality tell what everybody already knows, which is maybe the sea level will rise, if you believe the BS. It's not impossible for them to impose fines, but remember, no matter how many commissioners, Republican commissioners, Donald Trump has gotten Republican commissioners onto the SEC, but no matter how many he may appoint, everybody in the staff is a committed Democrat who believes in climate change. So that's the SEC. So now I'm going to get to, so where is Exxon going with this? It's not an everyday strategy to bring a case in Fort Worth, Texas, against state attorneys who work for municipalities in California, seeking their deposition to compel them to come to Texas, let alone. Now, the complaint on its face only seeks their depositions, but it suggests that there is a wrong, which is abuse of process, which is something you could sue for. Abuse of process meaning you say you brought a complaint because of supposed damage from sea level rise, but in fact that's not real. What you're really trying to do is silence me in the public debate or something else that's unrelated to what your claim says. That would be an abuse of process, and they suggest that's where they're going with this after the depositions. Well, if you think about how a case, like the case of the California municipalities, might play out against Exxon, here's the way it plays out. First, there's skirmishing. Oh, they try to remove to federal court. By the way, it's a terrible removal. Exxon has tried to remove those cases. It's not going to stick. 6 months from now, a year from now, they'll be back in the state court. Time for the motion to dismiss. And then that'll take a year. So you're not going to hear a lot from these lawsuits for quite a long time. But the trouble is, when you get to the merits, there's no divorcing the merits from the risk of loss for Exxon. And so if you actually are going to litigate whether sea level rise from global warming is BS, well, if somebody believes it, you could actually be facing liability as a company. Now, how about this lawsuit? This lawsuit says, I'm going to put this, I'm talking about Exxon's lawsuit in Fort Worth, Texas. I'm going to put the merits on trial if I can get a judge to let me do it. I'm going to put the merits on trial right now. I'm going to call those city attorneys from California down here into Texas. I'm going to potentially, remember this, the politicians in California have nothing on the line at this. The lawyers are either on a contingency or they're being funded by environmental groups. There's nothing in the city budgets. There's no line item in the city budget that they could ever be criticized for this. Oh, now suddenly somebody says, how about some personal liability for you for abuse of process? How about some personal expense for you to hire lawyers to defend about my claims? How about getting the science of sea level rise on the table in a context where I'm not going to lose $1 billion if I lose on that issue? There are some reasons why Exxon is pursuing this approach. Okay.
Well, as you can see, there's a lot at stake here. And so what I wanted to kind of do, we're going to have just a little bit of panel discussion, and then we'll open it up to audience questions. I mean, I guess there's a political strategy, obviously, here, right? I mean, these are politically progressive cities in the politically progressive part of the state, looking for issues for election and politics, for advancing their personal political agendas. And as you pointed out, this is on contingency. 23.5% of anything that the lawyers win goes into the pocket of the law firm. And so there's not a lot at stake in terms of the cities. I guess one question that comes to mind is if you look at the strategy they're using here, it's very similar to what was done, for example, with lead paint manufacturers, where in fact the lawsuits demonstrated the manufacturers knew there was a problem, they acted to promote the sale of the product, produce the product, even though they knew that, and at the end of the day, they were liable, they had to settle a lot of claims about this nuisance that they created. And so the strategy in most of these lawsuits, and I think in the case of all the cities and counties at this point, on their side is this nuisance approach. And so I guess one question for this panel is, does that seem like a plausible strategy in this case?
Let me take a crack at that. Their problem is in connecting up with the actual harm from the bad deed. Okay? So in tobacco, you sold cigarettes to this person, they got cancer. In lead paint, you manufactured a product with lead paint on it, it's now peeling off of these houses, and especially in the poor areas, and we're ending up with a lot of children with lead poisoning and very long-term health effects. It's a small group. You're absolutely the people who did this. And there's a few companies that may have gotten out of business, right? Now we're into global warming. You are a part of the problem, assuming we can prove the problem. And it's not even a big part of the problem. And you didn't actually cause the problem. I mean, you sold a product that everybody needs. So if Exxon stopped selling gasoline and Chevron and Conoco stopped selling petroleum products in the 70s, we're back to Gray Davis's ideas during the energy crisis here in California, turn off the lights. You know, we're not building any new nuclear plants. We're not getting a lot of power out of wind, not getting a lot of power out of solar. Maybe there's something else down the road, but it's not here. What could they have done? Say, here you can put this gasoline into your car. You can go ahead and buy the really big crossover vehicle because it counts as a truck for the fuel regulations, and you know, everyone in single passenger Explorers and like the Armada, the Nissan Armada. I love that name. Are they going to stop driving it? Are they going to stop putting gas in them? You know, this is a problem that if government was really concerned with it, they could have leveraged their ability to tax the fuel. But government itself is using the fuel. They generate electricity. They have vehicles. They have lights in their buildings. So it's a very different problem than the lead paint problem.
I think it's interesting to just add some historical perspective about what happened with the tobacco industry. So in the late 90s, the big tobacco companies settled with a coalition of states, and I think some counties were involved as well. And the claim was that tobacco was increasing healthcare costs that states and other governments faced with their Medicaid programs and other health spending. And they got a huge settlement from the tobacco industry, and it was an annuity that was being paid over many, many years. It's interesting in two lights. First of all, to Anthony's comment, that was a case where clearly smoking cigarettes caused cancer, and that was really the thing that was responsible for it, whereas the contribution to global warming of gasoline sold by these companies that are being litigated against is only a very small proportion of the total amount of greenhouse gases going up into the atmosphere. So I think that's a big difference there. The other reason I wanted to bring this up is it really shows you the problems with municipal finance. So states knew that this money was going to be coming in year after year after year, and they were really thrilled about it. So they were so anxious to spend the money that they decided to securitize it. So instead of just waiting each year for their $100 million or $500 million to come in, they worked with banks on Wall Street to say, well, let's take the present value of that, and we'll just take it all now and spend it now, because we can please voters now and get reelected. The problem with that was, as people started to move away from smoking, the amount of revenue that was coming in from these tobacco settlements declined. So in many cases, the securitized bonds that those agencies issued came under default risk. And I think at least one case in New Jersey, they really had to backfill the money with other proceeds. So it just strikes me as being an analogy to what I think they're attempting to do here and how that might backfire.
Actually, from working on my blog, I have some numbers of what the market shares are. One of the complaints in one of these cases that I read said that Exxon has a 5%, Exxon alone has a 5% market share of carbon dioxide emissions since the company began back in the 1800s. But of course, that is a way of looking at it that grossly exaggerates it. What of course has occurred is that Exxon was very dominant at the beginning and gradually has shrunk and shrunk. Today, all the growth, and the market share of the major oil companies is shrinking, shrinking, shrinking. All the growth is in what? It's in fracking, which is not the majors, and it is in basically coal in the third world, China and India, which had nothing to do with anybody who could ever sue in the United States. So.
I guess as you look at this, I mean, one part of the storyline that we haven't talked a lot about is sort of the litigant side of this and how that evolved. And one of the claims in the abuse of process argument has to do with a meeting that took place in La Jolla, where a bunch of advocates for environmental causes met with some of these political actors and actually devised a strategy. I think the gentleman's name is Mala. Is that right?
Powell. Matthew Powell.
Matthew Powell.
By the way, these documents came out through some of the Freedom of Information Act requests that my client was working on, not in the litigations I was doing, but through requests by my client.
And so the consequence of this was there was a meeting where this was decided on as an intentional strategy. These lawsuits against the oil companies as an intentional strategy. And so I guess one question that comes to mind in the midst of this is, to the extent there's collusion, I know collusion's a big word these days, but to the extent that there is, does that even matter in this process? I mean, because that seems to me that in some ways that at least shades the argument that Exxon's making in the trial. So I guess one question is, does it even matter?
Remember that the lawsuit that Exxon has brought in Texas is only to seek discovery in aid of a potential real lawsuit at this point. However, they say in the complaint that the thing that they will be looking into, that they might bring a lawsuit on, is abuse of process. Abuse of process meaning misuse of the litigation system and its processes for a cause other than just winning this lawsuit. Winning the lawsuit is legitimate use of process. You're actually really seeking money. But if what you're seeking to do is disable someone in the political process, and there's a series of quotes from the meeting that are in Exxon's complaint, that what they're trying to do is delegitimize Exxon as a political actor. Those are the quotes from that meeting, and this is the strategy of how we'll do it. Well, okay, so that sounds like an abusive process, and this would be the proof that it's an abusive process. Is collusion the right word? I mean, it's how do you prove abuse? How do you prove that their motive is to accomplish something other than the stated goal of the litigation? I'd say it's part of that.
As we look at the other side of this and we look at the bond statements, obviously being able to borrow money in the public marketplace is an important aspect of public finance. Will this change how these jurisdictions actually issue their bond statements? I mean, beyond just amending the ones that they're already on the line for, will we see other cities in low-lying areas? For example, in the Miami area in Florida, or, will we see changes in their practices?
I think you'll see that. You already see credit rating agencies talking about changing their methodologies to include climate change. So clearly the sea level rise is the most tangible manifestation of climate change that could affect municipal finance if we believe all of this. So I think rating agencies will be asking tough questions about cities, about how you're modeling and what your thinking is about the level of risk that adds. There was some litigation with Illinois cities back in 2014 about they're not properly preparing for increased sea levels. So yeah, I think it was six villages in Illinois, actually, yeah, in Cook County. Well, we're on the way. The lake is rising. Or raining or something like that. Yeah.
But I would ask the question, so suppose Marin County puts in lock, stock, and barrel its entire complaint against the oil companies into its bond prospectus. Is it going to have to pay an extra nickel to sell bonds? And I don't think so. Now, I mean, for example, if you thought that climate change was such a huge risk, well, then the government's going to shut down Exxon, but the market values it at hundreds of billions of dollars. So the fact is, the market knows all about the climate change hype and doesn't believe it. That's my opinion. By the way, I'm not an expert on the market.
I think that's generally the case, but if a rating agency downgrades a particular issuer because they don't have an adequate response to climate change, or because the feeling is they have a lot of exposure to climate change, the municipal bond market is not particularly sophisticated. Lots of investors just look at the rating, so if something falls down from AAA to AA, the widows and orphans that are normally in that market are going to be gone because they're told by the broker to only buy AAA. So I think there is a risk there for individual issuers.
Given the credit rating agencies' mixed record, going back to 2008 at least, as a recent example of completely missing the mark in terms of assessing risk, should we be worried that they're allowing these kind of inconsistencies in filings?
Well, I mean, in defense of credit rating agencies, which I don't normally do, they're not responsible for policing everything that's in the filing. I think the question is, should climate change be part of the scorecard that a rating agency applies to calculate the default probability or expected loss on a bond? And I would say, generally, no. Marin County is a great case. I mean, I live in Northern California. Sorry about that. But Marin County is a huge place. Only a very small portion of Marin County is anywhere near the water or the bay. So there are many areas of Marin County, even if we believe this narrative, that would be totally unaffected. And so the economic engine that is Marin County would be unlikely to be that heavily impacted by this. So I find it really hard to defend the idea that that something is going to be downgraded because of this, but that's what rating agencies might do.
I mean, $50 billion is a big impact in the case of San Francisco, between public and private costs. I mean, it just seems to me that if that risk is real, as they claim it is, that there should be some public acknowledgement of it.
Well, that does raise the question of, if there is that risk, and it's not going to affect the prices, why is it in the bond offerings?
I'm going to suspect the next bond offering is going to happen.
It's because they didn't believe it. Oh, because these were made at the same time. The bond offering came out in 2017, the litigation came out in 2017.
And they're signed by the same person, too.
Yeah.
Signed by the same person.
So this may come back to haunt them. There might be a good procedure for them to use in the litigation to bring up the bond prospectus, signed by the same person.
Yep.
And here you said this, now you're saying this. We've got a conflict here. You know, are we going to apply a estoppel against you to prevent you from saying what you say in the litigation? Or, you know, are you gonna have to go back and say, no, we lied on the bond prospectus, and, you know, with the SEC looking over your shoulder? They're gonna be put into a very uncomfortable situation.
I thought it's interesting that in the San Mateo filing, they talked about San Francisco International Airport, SFO, being low-lying, being near the bay, and potentially going underwater. And that's owned by the city and county of San Francisco, even though it's not within the geographical area that the city and county occupies. And that's a major infrastructure entity that needs a lot of bond financing. So it's really interesting to me that they could potentially lose market access because of this type of discussion.
In New York City's claim, which was one of the most recent filings, I guess they claim that they're the American city most vulnerable to major coastal flooding and sea level rise, putting 245,000 of its residents at risk. Another study predicts that by 2030, storms as intense as Hurricane Sandy, which cost more than 40 lives and cost $19 billion in damages, are likely to hit every 5 years. I guess the question in the back of my mind, and I think in most people's minds as they read this, and I think Anthony brought this up, but I just kind of want to come back to this. How can you predict the weather with that kind of precision? I'm struck by, we had an El Nino last year going into our rainy season. And the weather forecast was, it's either going to be the driest year on record, the wettest year on record, or somewhere in the middle. You know, I don't have to be NOAA to make that forecast. And I guess the question is, and I understand the nuisance argument, but it seems to me that there's an argument about damages that even if they occur, proving the counterfactual seems almost impossible. So is in fact this just a legal strategy without any substance where when it comes time to actually try the case, you're not going to be able to make a case?
But that's an interesting question. If they get to try it in a San Francisco Superior Court, you're going to have juries who already take this as an article of faith. In fact, they hold it more dearly than many people of faith hold their faith. And so to prove the counterfactual, it's going to be a tough road, which is why I think Exxon's doing all of its lawsuits, because they don't want to have to face a San Francisco jury. There was a San Francisco jury that let one of their county supervisors off from murder because he had too many Twinkies. So they bought that argument.
Famous Twinkie defense. All right, we want to make sure to have some time go ahead, Francis.
I was just going to remark that you were talking about New York, and New York is very exposed to sea level. There's no question about that. The sea is all around the place. One of the things I've put on my website a few times is a picture of the headquarters building of Goldman Sachs, which is about 100 feet from the bulkhead, maybe 20 feet above mean high tide at best. And I think that shows you what the smart money thinks about this. If you look at the east coast of the United States and where the storms go, it's very hard for a hurricane, which they tend to be curving up the coast, right? Very hard to score a bullseye in New York. A storm did in 2012, but it's very hard. And if you look at statistics going back, which I did back to 1900, the number of Category 3, 4, and 5s that have hit the Gulf and Florida and the Carolinas is 40 or 50 compared to 2 or 3 that hit New York. It's just very hard to hit it.
We wanted to open the floor up to questions from the audience, if there's any questions.
I'm curious, would individual taxpayers have any standing if, say, the abusive process proves that the city credit rating is injured for future bond issues, or if the SEC comes down and fines the municipality, and then the municipality has to pay tax revenue to cover that fine? And if in fact they do have standing, what would the penalty be? Because you don't want it to be more tax revenue to go to them. What can there be personal liability?
This is an excellent question, and I see you're looking at me like I'm gonna know about standing. The question of taxpayer standing for taxpayer lawsuits is, it would justify multiple law school classes to try to understand. And I mean, I'm going to tell you in general, I would be very doubtful, but there are creative people who might come up with something, but I would be very doubtful that you could get it standing for a taxpayer lawsuit on that. But by the way, some of it depends on their different rules in federal courts. Each state, it's a very, very complex subject.
In California, we let taxpayers sue for anything. Federal courts, they can't sue for anything. So it's just the mirror image of it. So, yeah, you could have a taxpayer sue for, basically the taxpayer standing is to restrain a misuse of public funds, which would be a false bond filing. But your remedy is going to be limited to more taxpayer money. So it's not going to do you a whole lot of good. You might get an injunction.
So there couldn't be any personal liability to the agent?
Usually not. Usually not. Those, the courts are very leery about opening up to personal liability. There's all sorts of immunities that apply to public officials.
I just want to say that in all those enforcement cases that I listed earlier, I'm not aware of any taxpayer litigation following it. Doesn't mean it didn't happen, but it didn't hit the bond buyer.
Yes, I'm fine with them, considering that I would imagine he must have known that Exxon, when it was going, if they were going to do a countersuit, would have looked into something like the difference between what they're saying on the bond rating reports and what they're saying on there. That sounds like kind of an odd thing for them to do, considering that was I guess most attorneys would figure, well, the other side's going to do something like this and they're going to look into bond ratings. How did this come about that so many cities seem to act like nothing like that was going to happen?
Well, how it happened, I don't know. I mean, there was a law firm, Francis, you were mentioning some law firm that did this research and pulled up.
Paul Weiss, I don't
all
know
of these
who's heard of that, but
inconsistencies.
it's a very prominent litigation firm in New York.
And just discovered all of these inconsistencies. It's like they were expecting you not to know what their left hand was doing and their right hand was doing. They obviously did, but they didn't expect anybody else to figure it out.
Both the bond prospectuses and the complaints are signed by the city attorney. The city attorney, or maybe it's the county attorney or whoever the head legal officer of that municipality. Those people had almost nothing to do with writing either document. Did they read them? There's the question. And the answer is the conscientious ones kind of read through them quickly, and the non-conscientious ones didn't. And is it possible that this didn't register with them? Absolutely possible. I mean, in terms of these environmental lawsuits, this is subcontracted to somebody else, and someday we may get some money, and it's not costing us anything, and that's where they are.
Well, and the bond stuff is subcontracted to somebody else. So you got private law firm A, which or actually, doing the bond prospectus. They're doing all of this compliance work for the cities, and then you've got the personal injury attorneys that come up with this great idea for this
Matthew
lawsuit.
Holland is the guy.
Yeah.
His name was.
To do this litigation here, and they live in completely different worlds. They're not talking to each other, and so they didn't. But as I said, in the San Francisco bond offering, it says they lay out a report. There is a report that says these bad things will happen, but then they get down to their disclosure and says we don't know. So it's kind of interesting that they're citing that and coming up with the we don't know. They obviously think that there is some sort of impact that they will feel if they come up in their bond prospectus and say the city's going to get wiped out in 2050 if things keep going the way they are.
Hi. Well, thank you for your comments. I wanted to just offer an observation, then maybe I'll give Francis a bit of a hard time as he's a contrarian. And it's been too easy for him so far. So the first observation, I suppose, would be that if you're the first municipality or state to go and put in a whole myriad of risks in your offering, you might actually encourage attention, and you might struggle. Just maybe it's 0.5% or something in your offering, right? So you've got somebody going out there and actually putting an offering together, and you need to get critical mass of buyers. But if you're the first person going out there with extreme views about the risks and potential for risks, you position yourself to actually stir the market. Right? So the market's actually concerned, and you might limit your ability, not necessarily to sell, but at the same level. If you have a 0.5% additional, 0.5% per annum additional coupon for 20 years, that's real money. I wanted to posture that on these bond cases, and I know the general theme among the panelists is that there aren't many bond cases and that there are no damages. I think there's an alternative perspective as well. We've seen in Volkswagen, we've seen class actions that have been quite successful by people who aren't necessarily proving that they are damaged. There's emissions, the quality of the air is maybe worse, but people don't have to necessarily position themselves as being personally damaged and less healthy for the quality of the air. There are other bond cases. Francis, we talked just a little bit about subprime. Some AAA securities landed up paying off in full, but yet litigation pursued and is ongoing that has elicited quite significant recoveries. And the theme, there's a third example I'll give you, which is Takata with these airbags. You don't actually have to be the victim of an exploding airbag to potentially participate in the class action. But the theme is that damage is not necessarily the actual death or illness or suffering of monetary loss that's noticeable. It could be the exposure to a heightened risk that you don't necessarily know you're exposed to. So if you invest in Volkswagen bonds, and there is a Volkswagen bond action out of California, you're investing in a company that you thought was producing, let's say, higher quality cars than the true nature of the car. Maybe they're closer to being a Ford than a less credible company. And as soon as that disclosure is made, the market reconfigures, right? So your insurance cost, your credit default swap spread widens, your bond yields widen, and the theory then is that when you bought that bond originally, maybe it was 10 years ago, you were buying into a company that had a different nature. So with that in mind, do you see potential damages?
Well, with all those things, so the world of litigation, civil litigation, is filled with gazillions of possible claims, and every such claim comes attached to a damage theory that might work for that claim. So one possible claim is a securities fraud claim. So your prospectus failed to mention some important risk. I bought based upon that omission, because omissions count as fraud in securities. They don't outside the world of securities. So I bought based on that omission, and subsequently the value of my security dropped. So a securities fraud case is based upon false statements or omissions in selling the securities. Okay, you got that. But with if you bought a bond, all you're entitled to is to be repaid on the bond. So
you can get rescission. Rescission in the legal courts, if it's blue sky, gives you an alternative bond which you would hypothetically have bought into, and those are often, let's say, paying 7 or 8% in some of these legal jurisdictions. So that's real. That's a real.
Yes, this is correct. So if in fact these bonds become only saleable at much higher interest rate, and if you have bought it recently enough, because there's a relatively short statute of limitations on this, yes, you could seek rescission. Perhaps I should have mentioned that, again, because I don't really believe that these bonds are going to be going down. I'm dubious about it, but yes, that is a possibility. And you also mentioned another possibility, which is some kind of personal injury lawsuit, right? Like for Volkswagen.
Oh, just as an example.
Or personal injury or property injury. So that would be another theory of liability, but not in your capacity as bondholder, not in your capacity as investor, or that your investment went down, but rather you were injured personally. Now, maybe I'm not clever enough to figure out what that, I never underestimate, this from my life in litigation, never underestimate the cleverness of your litigation adversaries to come up with something. I think I am not clever enough to come up with the theory of how they're going to allege sufficiently of personal injury from climate change or sea level rise, but again, never underestimate them.
I think it's fascinating to see the subtleties of the legal process. And I mean, this is a great example of a case where elected officials in this case are using the litigation process to overcome what they see as shortfall in the failings of the legislative and executive branches, legislative processes. And so this really, in many ways, I think the intent in many of these jurisdictions probably reflects that desire to force legislation through the back door in some ways, and to create accommodations to force these companies to make concessions. But their real goal is that, hey, we should be taxing these companies essentially out of existence to pay for all the stuff that we now have to do. I think the more interesting part of all of this, and we're out of time today in this conversation, but I think one of the more interesting parts of all of this, I mean, the original lawsuit from the Alaskan Village, where they were suing that the oil company it was Exxon, should help them move, was adjudicated in Exxon's favor, largely because of the argument that the legislative process should take precedence over the legal process in this case. And I think that, we'll see how this plays out. It may be that it's all about getting settlements in the medium term or the short term. I've got to believe that the stakes are so high for these companies that settlements are going to be hard to come by. I mean, unlike tobacco, where there's this, cigarette X caused cancer X or caused cancer Y, in this case, you've got other countries involved, you've got many global actors. There have been studies, I think there was one study that showed that the companies that were being sued accounted for 70% of carbon emissions in this study globally. But think about that, that means there's 30% that aren't engaged, and many of those actors aren't part of this suit. And so, I mean, I think that, one of the questions that we will see is whether the legislative process, and not just in terms of damages and remediation, but I mean, if you are San Francisco and you really believe that climate change is about to flood your downtown, I mean, a significant part of the financial district in San Francisco is reclaimed land from landfill. You should start building some walls real soon. I mean, that's always my critique of New Orleans. It's like, if your levees aren't high enough, that's your problem and you should worry about it, just like planning for earthquakes in LA. And so, I mean, I think one of the things that we're going to see as this unfolds is whether these communities are in fact really serious about this, not just for the political posturing that we're kind of seeing in these lawsuits, but whether they're serious about actually making changes to their communities that accommodate these things. And so, I mean, I want to thank our panelists for great commentary. And I want to thank all of you for coming today. I mean, this is these kinds of conversations, and I mean, this is just kind of an arcane legal dimension of a debate that's kind of exploded. We're going to see this continue to play out. The city of Los Angeles, I believe, is likely to follow suit in these cases. We're going to see a lot more actors across the country engaged in these conversations. So you're kind of at the, in the front row of a process that's going to unfold over the next 5 to 10 years. But that's part of what makes being at a school of public policy so much fun, and I hope you'll return when we have events like this in the future as we continue this conversation. So thank you.